Welcome to Broken Law, episode 131. I'm your host, Taonga Leslie, Director of Policy and Program for Racial Justice, and this is brought to you by the American Constitution Society, which is a 501c3 nonprofit, nonpartisan organization. Since this summer's landmark Supreme Court decision, which largely outlawed affirmative action in college admissions, there's been a ripple of controversy and legal challenges in a different space, which is employment, including lawsuits targeting many of America's leading law firms. To help us understand how the decision from the Supreme Court in the education context translates to the workplace is today's guest, Marcus Childress. He is co-chair of the DEI Protection Task Force at Jenner & Block, a role in which he helps companies and organizations navigate the political and litigation risks. And among his many other stellar accomplishments include serving investigative counsel on the House Select Committee, which investigated the January 6th attacks on the U.S. Capitol, overseeing more than 100 criminal investigations as a special U.S. attorney in Georgia, and also routinely advising clients with the Department of Justice, the Securities and Exchange Commission, and the Office of the Comptroller of the Currency and Enforcement Actions. Amazing. You've done it all. Welcome to Broken Law, Marcus.
Thank you. I'm happy to be here. This is a huge honor, and I'm excited to chat with you about these issues, although the issues aren't exciting, but I'm still happy to talk about them with you.
Well, I'm excited that you are doing some of this work and helping to demystify it for some of our guests. And to jump in, I think I would just start with asking you, what is the immediate impact from SFFA on employment law? And what kinds of practices, if any, do you think risk violating the Supreme Court's new or re-energized view of the law?
Yeah. So it's incredibly important, I think, that we have these conversations because we are in a new legal landscape. At the beginning, I think it's important to say that the SFFA decision applied to considerations of race in the admissions process for higher education, right? So it doesn't necessarily apply directly to private industry or companies right now, right? So that's, I think, important to say up front. But when I'm casually talking with friends or colleagues, I think the recent decision, if we're being honest, has had a chilling effect. And it's really unfortunate for obvious reasons. One of the more somber but important points that I just like to highlight, I think it's important to highlight from Judge Jackson that she made in her dissent, was that, given American history, right, and the origin of persistent race-linked gaps should be no mystery, right? We shouldn't be trying to figure out why there's gaps. And yet the court ruled the way it did, and here we are. When looking at the post-SFFA kind of landscape and where we're seeing issues, one is, for example, business operations. This is the first bucket that I like to think about these issues. And this deals with business decisions of whether it relates to promotional activity for customers, incentive programs, things of this nature that companies may implement. An example might be like a certification program that allows official certification so customers know that who they're buying goods from is a minority-owned company. Or like another example could be waiving fees of some sort from minority-owned businesses or products, right, to try to incentivize maybe that customers go to these minority places. And for this bucket, we're seeing claims that these business operations violate Section 1981. And for those who may not be as familiar, Section 1981 protects the right to make and enforce contracts and free from racial discrimination, right? So you should be able to enter and enforce contracts without being racially discriminated against. So under this statute, when thinking about contracts, it's important to think about the performance of the contract, the modification of the contract, and even like the termination of it. But more relevant for business operations cases, I think, is the enjoyment of all benefits, privileges, and conditions of that contract. So we've been seeing challenges to these business operations that I think, if I'm giving my personal opinion, right, is to try to create some good, try to push customers and consumers towards minority-owned businesses who may not have had access to these spaces in the past, but now they're being challenged under 1981 and also under state civil rights claims as well. The second bucket is probably a little bit more traditional, right? So reverse discrimination type claims. And for these, let's think about hiring and promoting talent. That's not the comprehensive list, but I think that's where a lot of these cases fall. So if a company has a special program to promote diverse talent into new roles, or if someone is fired, right, without cause and they're replaced by a person of color, and that person might perceive the reason is because the company's trying to increase its racial diversity. All right, this is the kind of fact pattern where you might see these reverse discrimination claims. And unlike the business operations, right, where we're seeing 1981 claims or state civil rights claims, this is where you see Title VII, which is a traditional employment discrimination claim under the Civil Rights Act. And it prohibits employment discrimination on the basis of race, color, religion, sex, national origin as well, right? And so for these reverse discrimination claims, think of hiring and promoting decisions, and then someone feeling like they're being discriminated against in those types of activities because of their race. And then the third bucket that I think is also important to highlight, because it's kind of everywhere, right, is board diversity, especially if it's a public company. These initiatives typically relate to increasing diversity on boards, because if you look historically, right, and even currently, a lot of boards just aren't very diverse. And so states have been trying to help encourage more diversity on these boards. And these laws have also come under scrutiny under Section 1981 as well. So now you have states, right, who might be getting sued for enacting these laws. And in at least one instance, right, the claim related to quotas for minorities, it survived the motion to dismiss. So the court allowed that case to continue. Whereas, for example, gender quotas, it was dismissed, right? So now you have where a court's explaining that racial quotas require a certain number or fixed number of spots exclusively, that can proceed for trial. Whereas if it relates to gender, that was dismissed. So those are kind of the three big buckets. There's other buckets, but that's kind of where the current lay of the land, where I think it's low-hanging fruit for folks to attack. That's kind of what we're seeing.
That is really interesting, especially those are, both from the statutes, but perhaps a similar analysis being applied to them. And I would like to, if you don't mind elaborating, I know that you can't speak to active controversies, but what are folks to say in defense of these claims? And what do you think the outlook is? Like, are some of these, do you think, more likely to fall or be hard to justify when weighed up against this? Are there ways that these could prevail? And what kinds of arguments would they have to defend them?
So what we're seeing companies do, I think, is challenging standing. These claims have become more sophisticated over time, but challenging standing and whether the plaintiff was actually harmed is, I think, one of the first go-to arguments on the company side. But I think a lot of companies also are going back and conducting assessments of their own programs, right, to see whether race is a requirement for receiving the benefit of the program or the promotion or even the policy, and making it clear, right, that there is no one race that can apply for certain programs, right? Everyone is welcome to apply or is welcome to the benefit. And for example, maybe your contributions to DEI or your contributions towards first generation law students or things that aren't race exclusive being the factors for how we consider these programs.
That makes sense. And hearkening back to my time in corporate law, one thing at the time that folks had expressed some interest in that at the time seemed not highly risky was more targeted recruitment and affinity groups, recognizing that certain specific groups have been excluded from the law and thinking that would be okay if we're just focusing on opening up the pool of folks who are being invited to apply for these roles, or once folks are there, making affinity groups available to support them in their specific experience. Can you speak to what legal issues, if any, these practices raise, and are there ways that companies can mitigate them or do them in a less risky way?
Yeah, I mean, when I hear this question, the first thing that pops out of my mind, maybe it's just recency bias. It's just all the express statements and programs that came into place post George Floyd, right? And it seems like it was forever ago, but it really wasn't that long ago, right? It was about 3 years ago. And so I think we saw outward pledges to increase diversity across all industries. I mean, like you said, even in the legal industry where we are, specifically when it comes to race, because race played such a big factor in the national dialogue post George Floyd. In addition to the risk that we went over a little earlier, I think when I hear about this targeted outreach, and maybe because I just left the Hill, I think what we've seen from Congress and state AGs is a really, really just great illustration of the type of risk that these kind of programs create. So one example, a senator sent a major retailer a letter citing their programs that were created post George Floyd for targeted type recruitment or targeted type activities, and cited the SFFA decision to express the senator's view that these programs should no longer consider race, right? It's no longer legal under SFFA. And it's not just Congress, right? We, in addition to the private litigants in the Congress, we have state attorneys general who probably are even more aggressive and have even more powerful tools at their disposal. And another example, right? So a group of attorneys generals sent letters to Fortune 100 companies about their DEI practices and some of these programs that you were just discussing. And some of that language popped out to me, included, right, treating people differently, right, is what they were saying because of the color of their skin. So this is language that you heard, right, early 1900 about treating people differently because they might have been Black, and now it's being used about treating people differently because you're maybe only considering a targeted group of people. And what's interesting for clients in this space and for all the challenges is that you're really having to thread a needle when it comes down to DEI right now, right? So let's just take the political and litigation kind of parallel track. Let's say this congressional member who is challenging your programs, or this state AG that's challenging your program, sends you this letter. And maybe you write back saying, look, we're rolling back these programs. We're not going to engage them anymore. They're done. But now consider progressive members of Congress or in states like New York or California or even Colorado who may not have the same interpretation of SFFA as that conservative member or that conservative state AG. And in fact, progressive AGs and Congress folks would say that the truth is SFFA only applies to admissions process, right? So you have no reason to change what you're doing at your law firm or at your company. So when companies are responding to these political inquiries, if they go too far, it could create situations where now you're being sued by progressive plaintiffs or having letters sent to you by more progressive AGs or congressmen. And I think it's just really creating an uncomfortable situation for companies. And so there's this component, right, where you have to consider the internal and external stakeholders. And I think that's what I'm really trying to get to, right, is you're talking to conservative and progressive members. You're trying to not have litigants sue you, but then there's also your employees and your customers. How are you discussing the DEI programs with them, right? How is that associate that was part of that targeted recruitment going to feel when you're saying you're no longer going to do targeted recruitment? And so I think these are the questions that companies are now having to think about and should be thinking about before they actually have to engage in the analysis, because it's probably not a comfortable exercise to be thinking about how do I want to talk to this fifth-year associate who was a member of this special targeted recruitment about why we're no longer doing it, as we're being sued by a plaintiff or having to respond to Congress.
So we hear sometimes from the smaller employers, the mom and pop shops in our network, they're looking to the really large organizations to set the tone of, okay, what's in, what's out, what's okay. And for many organizations, at least, what's seen is, okay, well, they're rolling back this program, they're dismantling this. I'd love your take on like these rollbacks or big adjustments. Is there, I guess, a dilemma in not having more corporations, stand and fight or take the argument all the way down the line? How does this square with, where we were? And you're right, it seems like ages ago, but in 2020, this surge that seemed to have burgeoning effects for diversity, and now this moment of like, okay, is corporate America stepping away from its commitments that it made back then? Like, just how do you square that? And is there any way to mitigate risk but still be making those commitments?
This is going to be such a case by case determination, but at the end of the day, I think companies and organizations, and let's say the mom and pop shops, are looking at the bigger companies for, how are you guys going to lead in this space? It's really going to come down to really establishing your values right now, right? And maybe not rolling back. I actually don't like the term rolling back or pulling back on our DEI. I think that there is a certain level of reasonability in saying that we are adjusting to this new landscape so that we can continue the work of increasing diversity, equity, and inclusion in our workspace, right? And maybe that means that our requirement can't just say underrepresented racial groups, right? Maybe that requirement now has to say, show me how you have helped increase diversity at your law school. And I always challenge people, where's the harm in that, right? If you're recruiting somebody who has shown you that during their 1L and 2L year, they were dedicated to increasing diversity and equity and inclusion at their law school, is that really a bad result? And I think the answer to that is no, right? And so it's just changing the way we think about this. I mean, the classic example I like to give is like, I don't think, at least if I'm making a hiring decision, I don't want to hire someone who is from a certain racial category just because they're from that racial category. I want someone who is here to help me increase that diversity within my law firm or within my organization. And I think companies now are, if they really care about it, are getting back to that basic of like, I want someone who wants to make this place more diverse and equitable, rather than saying, oh, I want one person of this category or two people of that category, which is not what companies are doing. But I think that somehow might be what the argument is skewing towards, right? So it's just controlling again what this conversation is, which is increasing diversity for those who weren't able to have access to it, and getting people who want to have a more equitable workplace. And if we all have the same mission and the same goal, then we can work towards doing it in this new legal landscape.
You're listening to Broken Law, brought to you by the American Constitution Society. If you're enjoying Broken Law, consider becoming a member of ACS today. You do not need to be a lawyer to be a member. As we discuss so often on this podcast, our laws and legal systems impact all of us. By supporting ACS, you support Broken Law, our work to diversify the federal bench, and our advocacy for Supreme Court reform. You also become a member of our nationwide network. Learn more about ACS by visiting our website at acslaw.org. And now, back to the conversation.
I want to ask you, since you touched on the contracting question, and this is not quite employment law, but there was also and still remain these ideas like private money that's trying to support minorities or historically underrepresented groups. So, for example, there are scholarship funds, right? And when I was applying to school, there were certain scholarship funds that were available and were targeted towards certain groups. And I actually have a friend who did, she was like Sons of Italy or something. So I think there are many, funds like this that exist, or incubator funds that want to, promote a minority-owned business. Are these also in the crosshairs or things that you think have potential legal risk attached to them?
I think they're still in the crosshairs, yes, unfortunately. And unfortunately, we're still operating in the gray. I mean, for these types of issues, as I'm sure you know, and a lot of the listeners know, right, it's still being litigated right now, even at the circuit court level. And the way that I oversimplify it, I'm really providing that caveat of oversimplifying it, is whether, right, the funds or the money or the scholarship provides a benefit, right, which it does, and then whether the requirement for that benefit considers race. And if it does, then I think you are in an area where you are susceptible to some type of litigation risk or challenge, right? Because the Supreme Court's decision in SFFA, I hate to be the cynical guy, but when I read the majority opinion and the concurring opinions, all I kept thinking was, you are very skeptical of any consideration of race, even though, in my opinion, this is my personal opinion, affirmative action and other programs, consideration of race was to remedy a harm and to help, right? It wasn't to harm someone. But that's not the way the opinion read. And so these scholarships, these grants, I think the way plaintiffs would challenge it is that I'm being harmed because I don't have access to it, rather than the angle being we're helping others who didn't traditionally have access to this space. So in one case, for example, an organization was sued for giving grants to business owners who are from a specific racial class. And in this case, the dollar amount wasn't even like crazy. It was kind of low, in my opinion. We're not talking about hundreds of thousands of dollars. And the claim for this situation was also a Section 1981 claim, right? So prohibiting discrimination in contracting. But now the question comes down to what constitutes a contract. Is a contest a contract? Is a scholarship a contract? And I think these are the questions that we don't really have clarity on. And they're still being litigated at the circuit court level. And there's also, right, in our world, our law firm world, and even in like banking and other places, right, where there's scholarships or fellowships. And a lot of these traditionally have related to diversity type fellowships of who can receive this money. And again, does this qualify as a contract? And I think it's really going to be dependent on the specifics of each fellowship and each scholarship. But if the money that you're giving out has a requirement based upon race, I think you are opening up yourself to having to answer these questions in some form of litigation.
And as a brief follow-up, you mentioned a couple of times that these battles are filtering through the circuit courts. Are there any cases in particular that you have your eye on that you think are worth following to kind of be bellwethers of where this is going? And do you see this coming back up to the Supreme Court anytime soon?
Yeah. So I am watching the Fearless Fund case pretty closely in the 11th Circuit. And I unfortunately think that because of some of the dicta in the SFFA case, I think we're gonna start seeing it. We're already seeing it applied to other contexts, like, for example, corporate DEI programs, right? And so I think we're gonna see dominoes for the next years, who knows how many years, where, does it apply in this context? Does it apply in that context? And who knows if it makes it up to the court for, ultimate decisions, or whether we just have circuit court decisions. But I do think that these are going to be matters of first impression now because of kind of the new landscape that's been established in regard to how we can consider race in the education context. And then people saying, well, if you can't consider it with admissions into school, then why can you consider it in this other context?
So we've talked a lot about some of the most, I think, direct and potentially riskier ways that companies have committed to increasing racial equity and the ones that are being challenged. But I'm also curious about what are low risk ways that companies can make an impact for DEI, for racial equity, that still maybe accomplish these great goals, but don't raise as many legal or constitutional questions.
I'm going to start with the recruiting side, because when I was in the military, I used to say you can't have equity and inclusion if you don't have diversity in the first place, right? So I do think recruiting is a big first step for any type of diversity program. And I think the safest way when it comes to recruiting is just casting a wide net. And I know, look, I'm in the law firm world, right? And we're all lawyers here, and I think it's pretty fair to say the law firm world is not especially big law, is not necessarily known for casting a wide net in its recruiting. And I think that leads to talent pools that aren't as diverse as possible, right? So are you recruiting from the same 2, 3, 4 schools? Because if so, you're dependent upon their diversity for the diversity of your pool. If you want to increase the likelihood that your candidate pool has people from different racial groups, different socioeconomic groups, different geographic groups, and I think just casting a wide net on where you're recruiting is like the easiest way to do so. I like to always bring up, and I'm sure my friends and colleagues who hear this will laugh, is like, why aren't we recruiting at HBCUs? For the legal context, right? You have Howard, you have North Carolina Central. You have law schools that are historically Black colleges and universities. That does not mean that the entire talent pool at those schools is Black. I like to make that clear. But since it is a historically Black college, the chances are it's going to be a more diverse pool than maybe some of the other schools that you're recruiting at. And I think that just naturally increases, one, the opportunity to find talent that you ordinarily are just closing the door to, but these are race-neutral ways to increase the diversity of your pipeline. No one's going to be able to challenge that you are being discriminatory in recruiting at Howard because you're recruiting at a school, right? It is not, I'm going to a Black school. I'm going to just Howard University that happens to be a historically Black university. And then I think another way, this isn't necessarily a way to increase diversity, but I think it is a way to protect yourself. And it's really, I think this is the time right now is to be conducting these internal reviews of your programs. It's important that companies like truly understand what is their DEI programs, what's included, like how are we recruiting, how are we promoting, what's our program trying to do, what's our goal, what's our mission, and are we actually accomplishing that goal? And then how are we talking about it, right? If we're talking about our diversity program like we're looking for racially underrepresented individuals, but yet one of our requirements is that it's not a racial group. Now we're setting ourselves up for a potential lawsuit when it's not even one of our requirements, right? So making sure our communications actually match what we're doing in practice. And then not just conducting the assessment, but doing it with counsel, right? We are in a litigious environment right now, right? And so if you're conducting this review and you're not getting a legal analysis, this may not be privileged work now. So if you do get into discovery, you're going to have to turn over all this really important work where you're trying to maybe fix your programs and turn it over to the plaintiff that can then use it against you. So engaging counsel to be able to get the legal analysis and have these safe, really important conversations in a privileged manner so you can protect it if you are sued. I just can't think of a better time to do it. And another thing I think it's important to highlight, right, when you do have, and I know we're talking about ways that are safe ways, but you got to consider like the shareholder side of it, especially for companies, right? There's a world where any move you make can come under shareholder scrutiny. And so, for example, casting a wide net, is that really going to hurt you if a shareholder puts out a proposal to review your DEI programs because maybe they don't agree with DEI? If a company is presenting to their board that, hey, look, we're recruiting at Florida A&M University, right? What's the argument against that? And so I think when you are thinking about these safe kind of approaches, you have to think about not only from the litigation and maybe political side, but also from the shareholder side.
You mentioned these having privileged conversations, and I wonder in terms of like, where do folks find these resources, right? Like, how do you, especially, if you're not McDonald's and you're not Starbucks, like what kinds of resources are available to folks who at least want to get smarter and thinking about these issues?
Yeah, so there are, the New York Bar Association put out a great guide on this that I think is a great starting point for anyone that's looking to make sure they're doing this in a legal way with the new landscape. I actually think that's just a great starting point. Reading, it's going to sound crazy, reading the SFFA decision. I'm not trying to be demeaning in any kind of way, but it's not hard to understand, right? What they're trying to prevent or what they're trying to overturn when you read the opinion. So I think those two are great starting places. Even for small companies, I'm sure even if there's one in-house counsel, I think just having conversation with even if it's like a one-person shop, having that conversation, I think is also just critical. And then if you do, even if you're not like a major corporation, I think talking to outside counsels and figuring out maybe fee arrangements to conduct these assessments, right? It's not like I think companies and organizations can kind of figure out like how big or how expansive their DEI programs are in a way where you can figure out fee arrangements. That way, the work that's being done is at least you can budget for it, right? It's not like it's going to be an expense that just keeps on going on forever.
One last question I want to ask. This is a bit speculative, but I think one thing that's been very interesting on Edward Bloom's side and the SFFA side is the way they've enlisted employees and regular people and to aggressively report on and flag all these different types of things that maybe weren't controversial before, but and that seems to be one of the ways that this legal machine has grown. And I'm wondering, what are there things that normal folks who are in support of DEI or would like to see greater equity in their workplaces do? Like, what are things people can do to jump in on that?
That's such a good question. And this answer is not legal, I don't think, per se. I'll just say, look, as a diverse first generation lawyer, I can personally tell you how much better I feel about my job when I have mentors who I feel like are guiding me and showing me the way. I don't know about you, but there's just no better feeling for me when I feel like someone's actually trying to look out for me and my professional goals. And so I think that's really what it is. I think it's going to take folks like us who care about DEI, remaining personally committed to it in our personal lives and making sure that we're looking out for that next generation personally, right? Like companies are going to have to figure it out. We're going to have to figure it out together. But in the meantime, while we're figuring it out, it doesn't stop me from going and talking at Balsa to make sure that like they know where to recruit or where to apply and where to get that clerkship, or going to any other affinity group, or looking out for that first year associate who may be a first generation or maybe from a lower socioeconomic class, or maybe the only Black lawyer in the class. I personally think while we're figuring it out, it's going to take just that personal commitment to mentoring and looking out for folks. And then for lawyers and legal departments, I think we're just going to have to be mission oriented in conducting these assessments, these holistic assessments, right? So yes, it needs to be opened up to the entire pool. There should be no race exclusions. But that probably should have been the case originally, right? Because like I said in the beginning, it's really about who cares about diversity, equity, and inclusion, who wants the room to be a diverse room. Because if we all have that same goal, we're all going to do it without making race a requirement of the program or the hiring decision. So it's really going to come down, I think, to people's personal commitments to this, right? Because you can't sue me for mentoring in my own personal time. And I think that is something that's important for us to remember. We're not helpless in this situation. We can take matters into our own hands. It might be a little tough or time intensive, but, it's not tougher than what they were going on before the Civil Rights Act was even passed. So I think we just got to continue with the good work.
Thank you so much. And thank you for the good work that you're doing and for taking the time to join us.
Appreciate it. Thanks. Thank y'all for having me.
Wonderful. And if y'all enjoyed this episode, please check out the other episodes from Broken Law. We recently heard oral arguments from Rahimi, and so my colleague Christopher Wright DeRocher was on for that one. I recently hosted an episode about the attempts to silence Anita Earls, and we thank you all for listening and doing your part to advance justice wherever you are. You can find our episodes wherever you're listening to us now, Spotify, our website, Apple, and please recommend it to friends and leave reviews. Thank you.